So, ladies and gentlemen, it's my pleasure to welcome you to the October 13th edition of Black Professionals Month. We are so happy to have you with us today as we come together to celebrate, connect, build relationships so that we can rise to higher roles of leadership and also generate sustained wealth. It's all about stepping up so that we can stand out and break through. We are here because you have said to us that we are fired up and we are going to make a difference. We're going to turn to each other, work with each other, and make it happen. So, ladies and gentlemen, it's my pleasure to present to some and introduce to others Mr. Keith R. Miles, estate planning and elder law attorney, and the owner of the law office of Keith R. Miles, LLC. His firm handles estate planning and elder law matters throughout the states of Georgia and North Carolina. And he has a tax background featuring work at PricewaterhouseCoopers, Merrill Lynch, Singular Wireless, and AT&T. He received his BS degree from Carnegie Mellon, JD from the University of Maryland School of Law, and MBA from the University of Georgia, and his LLM in taxation from the University of Alabama School of Law. He is a member of Wealth Council, Elder Council, the Estate Planning Council of North Georgia, the National Academy of Elder Law Attorneys, and the Association of Black Estate Planning Professionals. Plainly put, ladies and gentlemen, he is more than accomplished, credentialed, and capable of helping you with your estate planning. I think from what we just read, it is clear that he is highly capable of being able to do that. So, ladies and gentlemen, it is my pleasure right now to bring to the screen the next voice that you will hear will be from Keith Miles. And Keith, I am going to tee you up and let me change the view for a speaker. And it's all yours, sir.
All right, thank you, sir. Thank you, Hutch. I appreciate it. Thank you for the invitation and the opportunity. And anytime I get the chance to work with you, it's a pleasure. So I appreciate that. And thank you, Denise, also for helping to put this together. This is an incredible event you guys are doing all month. So I'm glad to be a part of it. I'm going to tell me you can see it, but I'm not sure. Can you see it?
Yeah, you see it.
Okay. All right. Thank you. All right. So today we're going to talk about planning for generational wealth in the Black community. Of course, with estate planning is an incredibly broad topic. Trying to narrow it down really to distribution of property after death, because estate planning can cover so many things. So we kind of want to narrow it down. I know hopefully the focus of this month is on Black professionals, corporate executives. So talking about a group that may have these issues of passing on property and trying to point out some situations where it may be some issues they need to be aware of. I try to put two families that, we have so many images in the world of our culture, and I try to bring two out where we know affluent families. One on the left, of course, the Huxtables from the Cosby Show, the Banks family from Fresh Prince of Bel-Air. Both of them would have some kind of need to do presumably some need to do some estate planning, many kids, stable marriage. So we'll kind of talk about how that would work. So moving now?
Yes, it did. You're on.
All right. Okay, thank you. All right, we're going to start with an overview. And Hutch, correct me if I'm wrong. I have about 25 minutes.
Yeah.
Mm-hmm. Okay.
Yeah. Go to 640, Keith. We'll have Q&A after that.
Okay. So overview. Why are we even talking about generational wealth? Why did I pick this topic? So if you're aware of what's going to happen in the next quarter century, we're talking about 45 million U.S. households will be transferring $68 trillion in wealth. Trillion, not B. TR, trillion. So we need to plan for this. This is the largest wealth transfer in history, and we will certainly be a part of that. So we want to make sure we're prepared and we know what areas we need to think about. And anytime you talk about generational wealth, you're talking about three different areas. Distribution planning, and I'll go into each of these as we go through it. Asset protection and tax planning. So it's not just a matter of getting it to someone. Usually you want to do some kind of asset protection to protect it for them. And then of course you cannot be concerned about taxes. So we're going to start with distribution planning. And please feel free at any point in time if you have a question. Is there someone who can track questions for me? Because I can't see if anyone has anything come through.
Just put them in the chat or raise your hand using the reactions and we'll be able to respond. Thank you.
Thank you. So with distribution planning, we want to really concern ourselves with four things. Who is receiving the property? Okay. Sometimes there's a question, is it going to be the spouse, the children? If it's a single person, are you going to have other family members? Are you going to leave it to an organization? You have to think these things through and make a positive choice. How do they get your property? Do they get it outright? Do they get it in trust? Do they get it through a will? Do they get it from beneficiary designation? So there's a lot of different ways property can go from one person to the next, but they're not always going to be the most effective and certainly not the easiest. When do they get your property? Some people, you want them to get that property now. Some people, you say, you know, they're not mature enough yet. Maybe I need to put some conditions on this. Maybe I need to wait for a certain age. Maybe I need to wait until they get a degree or get married or some other thing that you want to tie that receipt of property to. Maybe they never get it. Maybe it's a situation where they are someone who has a disability and they will never be in a position that they won't need management for it. What property do they get? Do they get a share of everything? If you have multiple children, do you pick certain items to give to one child and not another? The largest thing that we have always fighting over is many times is personal items. People usually don't fight over money. What they fight over are sentimental things. So you want to really think about what are you giving to each person and how will they feel, or the other person that doesn't get it, how will they feel and how can you resolve that? Okay, so we want to talk about some things about owning property. I want to start with joint tenancy because so many people come to my office and they say, I want to get my affairs together. I need to get a will. And the first thing I tell them is like, just tell me if you can, a little bit about your family, a little bit about your assets. And when I look at their assets, a lot of what they have is going to pass outside of a will, at least in the beginning. So for example, many people own their property if they're married as joint tenants with right of survivorship. And I give a little illustration here. If two people buy a home together, presumably husband and wife, they will each own 50% of their home. Now, if one of them dies, that interest, that 50% interest they had automatically transfers to the other, 100%. It does not require probate. It does not require any action. It happens by operation of law. Now, take our two families that we have here. They're stable families, the Banks, the Huxtables. They probably will not mind if that 50% share goes from one spouse to the other. Okay? But if you have what other families have, you may have blended families. Okay? And in a blended family, it's the second marriage or later, there may be a concern that if that property interest goes to the other spouse, that other spouse may leave it to his or her children, and your children may not get anything out of that property. So you want to make sure you don't just default to joint tenancy, or if you're not aware of what your deed says on your property, you make sure you find out. If it does say joint tenancy and you are not comfortable with that, then you need to change the title of how you own that property. And I'm going to tell you next what that would be. So most people that would want to pass along their property would be tenancy in common. Okay? So two people buy a home together, and it does not have to be husband and wife, it's just any two people. They can decide the percentage for ownership. That's a difference, one difference between this in addition to how it passes. I'm gonna go back a slide. When you have joint tenancy or right of survivorship, it's 50-50. It has to be equal. If there are three people, it has to be 1/3, 1/3, 1/3. If it's four people, everyone gets a quarter. There's no differentiation in ownership percentage in joint tenancy. Tenancy in common, you can now pick 60-40, 80-20, 75-25, whatever you want to do. Okay. At that point, when the owner dies, whichever one it is, their piece of that property will pass through either their will, if they have one, or what we call intestate, where the court has a statutory scheme that will decide where that goes. So this is very effective for those situations where that person wants that property to pass down. So you see here that 60%, if that person had 2 children, 30-30, they split it. So they would basically have now from 60-40 to 3 people, 30-30 and 40. Okay. Another part of distribution planning that we want to always point out to people is, even though they come and say, I want a will, they have to realize a will does not control many things, especially high dollar items such as 401k, life insurance, individual retirement account, your IRA. All these things pass by beneficiary designation. Even bank accounts will have something called a POD, payable on death. Stock brokerage accounts will have TOD, transfers on death. So most of the time when people come, if you looked at the dollar items that are on their list of assets, the most dollars are going to pass outside of a will and directly to someone by a paper form. So we need to make sure when you go to a company, especially if you get something through your job, you know what it says. Because what happens many times is someone goes to a company, they fill out a form, they may change their marital status, and then they never update the form. How does that usually cause a problem? What happens is they come, they're married, say they go to Edward Jones, they work for Edward Jones, they're married, put the spouse on the beneficiary designation. They later get divorced, never update the form, they die, the ex-spouse gets all their money. The other family members might have had a will that says, I leave everything to my children, ex-spouse gets those funds. So you have to know when you are doing estate planning what each and every item is around your property. Many times we talk to people about possibly doing trust. They know that they've heard of a will, has probate, and they have some bad experiences sometimes. I hear horror stories. I had to go and took months and years to try to go through this. So they say, I want to try to do a trust. I want to avoid probate. So I want to always talk to people about trust and explain to them what it is. Every trust that exists, there are many different types of trusts. It is not just one type of trust. So when you come in and say, I want to trust, we have to talk to you, get the details of what you're trying to do, and then that will direct the attorney what kind of trust to give you. But they all have the same basic structure. Grantor, the individual who establishes the trust and decides what assets go into it. If you are the person who's establishing trust, you're the grantor. Trustee, the individual or institution, it could be a person, it could be a company that manages the trust assets. So you can make yourself sometimes the grantor. You want to do a trust that you control while you're alive. Other times you have a different purpose where you may want to try to seek asset protection and you don't make yourself the trustee. So grantor, trustee, and of course, beneficiary, the persons, entities that are benefiting from the trust assets. So every trust has these 3 components. And if you set it up correctly, you can at least at a minimum avoid probate, but you may be able to do other things depending on the way the language is written in that trust. So you have to understand that when you have trust, it is definitely a customized document. It is not a do-it-yourself, let me go on LegalZoom and try to put something together. Okay, you need to talk to someone who, and not every attorney can do it. You need to talk to an attorney that focuses in this area. If you talk to an attorney that has multiple practice areas, you know, and they don't focus on this area, you may want to seek an attorney that does. So I mentioned there are many different types of trusts. There are 2 broad categories. Okay, they have many different names on the irrevocable side, but you have revocable and irrevocable. Revocable terms can be changed. Okay, if I make that trust in October 2021 and get it signed and up and running, and decide in 2023 I want to do something different, I can amend it or I can undo it altogether. That's revocable. irrevocable. Terms can't be changed. I put it together. I will pretty much lock in what the design of that trust will be. Why would I want to do that? Main benefit, irrevocable assets out of grantor's estate. What does that mean? It can mean a tax reason where I'm trying to push those assets out. Maybe I've contributed stock. Maybe I'm anticipating that stock's going to grow, and I don't want the value of that stock in my taxable estate later, years down the road. So if I can put that, Microsoft stock in when Bill Gates is still in the garage, and then 10 years later, I'm $100 million. That $100 million is not part of my estate. I have avoided many estate taxes. Also, asset protection. If I don't have it, it's not exposed to my creditors. And by creditors, I mean potentially lawsuits. I can mean bankruptcy. I can mean potentially divorce. So you have a lot of situations where you may want to push property out of your estate. And the only way to do that is to have it be irrevocable. So if you have a trust, some people have trust that they have set up because they wanted to avoid probate. So they've made revocable trust, but that does not offer you the ability to do any asset protection. So you see here, main drawback of revocable assets still in your estate. The law says if I can go back and get it tomorrow, then technically I've never gotten rid of it. So if you get sued or have a lawsuit or something that happens, they can come after not only you individually, but go to the revocable trust and go seize the assets there. So uses at the bottom, you see revocable trust help managing affairs. One of the big reasons, even if you don't get the asset protection, is you still get the ability to have a structure there where you could have assets managed, either for yourself. So maybe down the road, you're worried, I might have dementia or maybe some situation where I cannot function anymore. I want to have this trust in place where I can appoint a trustee and some terms and have it managed for me, even if I'm not able. Of course, move assets to heirs faster at death to avoid probate. Irrevocable, we mentioned reduce estate taxes and protect assets from credit. So this is a very, very critical tool. And to understand when you're going to talk to an attorney and say, I want a trust, you really have to know what are you trying to get out of it? Because there's a vast difference between what an irrevocable trust will do for you versus a revocable. So we kind of have two things, a path of non-probate assets. Like I mentioned, joint ownership. Right? Does the asset have a joint owner? Say a private residence. Yes, joint owner inherited. So that first spouse passes, no probate. If their second spouse passes, now does that asset, same house, have a joint owner? No. Why? Because at that point, they're the second to pass. They're the sole owner at that point. So now it may be a probate asset. Okay. Does the asset have designated beneficiaries? Life insurance, IRA. Yes, that is who inherits. No, if it doesn't have designated beneficiaries, sometimes that's a problem. People have many lawsuits. I mentioned if they have old names on there that might get it like a divorced spouse, but sometimes they have names, people have passed away in no one's name, or sometimes the form is not located. I was listening to something today. There's a situation where a company was merged. They were at the original company, a new company merged with the old company, took over the 401k plan. The person never filled out a new form with the new company. So he had no beneficiary designation. What happens then? It depends on what the plan says. So then you're at the mercy of that plan document. Some plan documents will make it payable to surviving spouse. Some people then to the children have an order. Some will default right to the estate, so will become a probate asset. So you have to know the details on every single piece. Is the asset owned by a trust, or does it name the trust as a beneficiary? Yes, trust beneficiaries inherit. So when I say beneficiaries, I can mean an individual. I could have my IRA that pays to my children and name them, or I can set up a trust that we mentioned, the revocable, irrevocable, and have the assets paid directly to the trust as the beneficiary. Either way, that will avoid probate. So if I pay it to a person or pay it to a trust, it does not need to go through a court. in order to pass. Okay. So probate, excuse me a second. So probate, if your asset is in your name alone, okay, as I mentioned, the house, the personal residence, you're the surviving spouse, you have the house, there's no way for you to pass that along if you pass away, except to go to court. At that point, title is suspended. Okay. So the question at that point then is, if people are familiar with probate, you have two different options when you go to probate. Either you have a will, someone took the time to write a will, or someone did not. Most people, to make it clear, we all start intestate, right? We come out of birth with no will, so we start intestate. Up until, depending on what state you're in, you cannot make a will until a certain age. In most states, it's usually 18. I live in the great state of Georgia. We have a different rule, it's 14. So basically, you could be in high school and start writing a will. If you make a will, you're essentially opting out of the state's intestate scheme. So what the state does is say, if everyone passes away without a will, we're going to have a problem, because now people will be coming forward saying, you know, mommy, daddy was meant to leave me this, we had this conversation, this, that, and the other. The court's trying to avoid all that. So what the court does is says, if you pass away intestate, what we will do is have a statutory scheme of who will inherit. There's no leeway, there's no testimony about whether so-and-so, you know, had a good relationship, bad relationship, didn't talk. Simply a scheme along usually bloodlines and adoption. So if you have stepchildren you want to take care of, they won't be covered. And of course, if you had an intention to disinherit someone, that won't happen because they will automatically get their piece. Okay. If you do your last will and testament, then you can specifically name people in your will that you want to get it. Now, there is a limit on that. Certain states want to make sure they protect spouses. So what happens is, if I am married to somebody and I decide that I'm angry, you know, with her, and I'm going to say I leave everything to my children and bypass her, many states will give her what's called an elective share, that spouse the right to claim a minimum amount of property. So it's not perfect if you make your will that it will be followed to the T. The state will protect the interests of your spouse. So what happens generally during the probate process? Person who has your will takes it down to the court authenticates it, makes sure you have witnesses, checks the signatures and everything. If everything's okay, appoints an executor, or if there's a no will, it will appoint an administrator. So when you hear executor, that means there was a will. Administrator means there was no will. Next step, once that person is approved, they get what's called letters. If you had a will, it's letters testamentary. If there's no will, letters of administration. Those letters are the court giving that person essentially an after-death power of attorney to go out into the world and get information and handle that person's estate. Identifying, notifying creditors is they have to tell the world, I represent this estate, this person is deceased. They put something in the paper, run it for a month usually, and then they can get claims, okay? So probate, the thing to understand is probate is designed to organize paying creditors when someone passes away. Then after that is done, then the excess can follow the will or the intestate. So it's 1, 2, pay creditors. Are the creditors paid? Are the debts paid? Then go to the point of distributing the estate. Okay. So when I say will, what does that mean? And the thing to understand, I want to make sure you understand, is wills are state specific. So one state may have a rule that another state doesn't. So I'm going to show you this. My last will and testament, I am Jared Smelly. I want my property to be distributed the following if I die. This is written on the legal pad, right? 1, all my property to my wife, Sharon, and she lives longer than me, except my 12-gauge shotgun, which I want my friend Tom Lee to have. If my wife dies before me, Tom still gets the gun, but I want my 2 daughters to get the rest, right? And then if all of them die before me, I want Tom to get the shotgun, and the rest to the American Cancer Society. Signed his name, February 12th, 2016. Is this a valid will? If I asked you, would you say yes or no? Probably most people would probably say, well, no, it's written on a yellow pad. It's probably not good. Well, the answer is it depends on what state you're in. So the states in red recognize holographic wills. I'm a member of Georgia and North Carolina bar. So one state, Georgia, does not. So if you did that in the state of Georgia, they would not accept it if someone brought that to the court. If that was the state of North Carolina, they would. So we have to be very careful of knowing the rules, because we can transfer property as African Americans, and if we're not sure exactly what we're doing and we're a little lax, depending on the state that we're doing it, we can potentially pass property, disinherit somebody. Okay, so you want to be very careful with what you're doing in this area. Most people will do a typewritten will. Okay, this is, you get on your computer, or you have your attorney draft it, type it up, sign it, witness it. That's going to be valid in all states. Now, I mentioned intestate. Every state has a scheme. I wanted to give you an example of what one state might do versus another. It could be drastically different. If you pass away, usually if you have children and no spouse, children will inherit everything and just split it. Spouse with no descendants. Descendants means children or their grandchildren. So if a child predeceases you, the grandchildren will step in. Spouse inherits everything if there's no other children or grandchildren. Spouse and descendants, and this is what happens a lot, is they usually wind up sharing property. Spouse usually always gets no less than 1/3. So if there's 2 children, they'll each get spouse 1/3 and the other two 1/3. If there's 5 children, spouse 1/3 and the other ones, whatever that ratio is. Okay. So you have to know your particular state's rules, and it will affect each person drastically. This is North Carolina. So North Carolina has a scheme where they actually try to put a specific amount of money to make sure the spouse is okay. So they'll throw out personal property worth a certain amount. Spouse will inherit real estate a certain amount. So this way, it seems like Georgia for the most part with the 1/3, but what they do is if you have no children and you had a spouse and your parents are alive, they'll split your property between your spouse and your parent. So you might go one day from being happily married, your spouse passes away, and if their parents are alive, you might have the house with one half with your in-laws. So it's a crazy situation. So you definitely want to go through the process of passing wealth deliberately, and try to work with an attorney to document all your needs. This is just to show you what usually happens when someone passes away and they may not have children. They go through a table, and it's kind of just an objective table. So they keep finding remote family members. So they will go find, grandparents, uncles, first cousins. They don't find them. They go over. Let's go up and try to find second cousins, third cousins. So they will find somebody, and if they don't, eventually it will be listed as unclaimed property. And after a period of time, it was called a skeet, and go to the state, whatever state that is. So you want to definitely make sure, if possible, that you decide where your property goes, or else the state will, and if it doesn't find anyone, it will keep it. I'm going to kind of go past this. I might come back on that, but I wanted to talk about heirs property.
Hey, Keith, I just wanted to mention we've got a couple of questions.
Okay, great. Okay, could you, someone read it to me? Is it possible? Or I think I can see it. Okay.
Do you want me to read it to you, Keith? Do you want me to read it to you?
Yeah, if you can, it'll be easier.
Yeah. So we have one from Celicia. In your experience, what category of assets are most often used in irrevocable trusts?
Okay, thank you. Good question. For me, in my practice, usually they're first concerned about the residences. So the private residence. Sometimes they have multiple houses in different states. So if you keep the house in your individual name, pass away, and the house is in another state, you have to actually have a second probate, which is called ancillary probate. So many times they want to try to put houses in trust to avoid having multiple probates. They first want to have the trust to avoid any probate, but they certainly don't want multiple probates. So that's one item. With the my practice, I'm what's called an elder law attorney. So for me, it's more than the property. It's usually focused on the goal of protecting somebody. So if it is someone with a special needs or disability, they're going to have to put pretty much everything in there to make sure that person doesn't have access to it, and make sure that they don't go over the resource limit that that government program has. So that would be one situation where they're trying to put anything that might come through. Other people that are coming to me a lot of times have minor children. So they are trying to put as much in there as possible, worried that if they leave things, say they had a Roth IRA, they're saying, okay, we know if the child is 5 and I pass away, the child can't receive the property. And then there's also now something called the Secure Act, where they can basically hold that property in the IRA for a period of time longer than adults can, until they become the age of 18, or actually probably later that if they're in school, and then they can have 10 years after that. So after that point, sometimes they want to pay it into the trust so that they can have management of a trustee that will decide, okay, if this IRA is large, I don't want to pay it directly to this person, because they can possibly take a lump sum out, go spend it, waste it. I want to have a trustee that's an intermediary in there who will decide when to withdraw from that IRA. So I usually see residences and retirement plans, and also, of course, life insurance. Life insurance is a big one because people usually, if they don't have a lot of property right now that they can put their hands on, they're banking on creating an estate at their death. So they will make a beneficiary designation on their life insurance policies to the trust, especially if they were single or if they're a surviving spouse. They'll do that. If they're the first spouse, they're both still married, usually what they'll do is make a designation to the surviving spouse first as the primary, so that if they are still alive, they'll be able to get the funds directly, and then make a contingent beneficiary designation to the trust, and then have it go there. That way, if both spouses are gone, then the trust will receive the funds.
Next question, Keith, is in your experience, what category of assets are most often used in irrevocable trust? And,
Oh, we just got that.
Oh, that's the one we just did. I'm sorry. If you are married, what are the benefits of having a co-trustee?
If you're married, well, I'm assuming that there's 2 different ways to have a trust. You can have separate trust, where I have my own trust and I make my own distribution rules, and my spouse will make her own trust with her own distribution rules. Or I can have a joint trust where we do it together, and then essentially serve in the beginning as co-trustees together. And then when one of us passes, then the question is, do I serve by myself or bring in someone, another person to co-trustee with me? So usually you don't have co-trustees with married people when they have their own separate trust, because the reason why they're doing this separate trust is usually if it's a blended family situation. So they're trying to make sure that they take care of their spouse, but they also want to make sure ultimately the property goes to their children. So they don't want to have the other spouse be the trustee if they pass away, because, or even while they're alive and becoming incapacitated, because they're worried that that property may not go to the children or maybe held back. So usually the only time I'm seeing people be married and co-trustees is when they have a joint trust. And so at that point, they're trying to basically just work together as one unit. So I've never seen the situation where a couple did a joint trust and weren't co-trustees. and I've never seen a situation where they were separate trusts and did co-trustees. So I wouldn't think that just being married would make you a co-trustee. It's kind of what's your goal for that trust.
Okay, in Florida, can you, see, I want to make sure I ask this question. Yeah, may you disinherit a child?
You can pretty much disinherit a child, I think, in all of the states. I'm not a Florida attorney, so I can't. My official answer is I won't give you a definitive answer, but I don't know of any state where you could not. When you disinherit, you do it either in the will itself, or if you have a trust, you can do it in the trust. But your question sometimes when you do it is how you do it. All right. So what do I mean by that? The first thought for someone is to say, okay, I give you nothing. I'm disinheriting you, so I'm giving you nothing. Well, if you give someone nothing, you actually increase the likelihood that they're going to try to challenge what you did. So say that I have a $3 million estate and I have 3 kids, and they would have normally gotten $1 million each. And now I'm giving the other 2 $1.5 million and one child nothing. So if I say I'm giving you nothing in the will, you have every incentive to challenge, because now you're saying, oh, if I don't challenge, I get nothing, so I have nothing to lose. So usually when we say disinherit, if we're going to effectively do it, what we're really going to try to do is give that person much less than we would have before, but enough to make them wonder if they should challenge, because we'll put a clause in there that says, if you challenge, you surrender the bequest that's given to you in the will. So you have to kind of set it at a mark that you think will discourage them. So if I set it at $5,000, they'll probably say, well, it's still worth it for me to challenge. If I make it $200,000, right? They would normally receive the $1 million. Now I'm making it $200,000. They might say, you know what? I don't want to risk losing the $200,000. I'll just take it, even though I'm not happy about it, because if I challenge this, I can potentially lose that. So usually we're not trying to fully 100% disinherit someone. We're trying to limit what they get in the impact they have on the estate.
Okay. The last question I see here is there a mechanism for the irrevocable trust to be amended if the entity no longer is in existence or died?
I'm not sure when they say the entity, because the trust is, as long as the trust is in effect. Now, the trust can be amended if it's revocable at any point in time, because the terms of the revocable trust will say it can be amended at any point in time. If it is a situation where sometimes what happens, the revocable trust, say, is deeded property, the person revokes the trust but doesn't update the deed, so now you have a deed on the books that's owned by a trust that doesn't exist anymore. Usually that's what's going to happen if people aren't careful, is they'll revoke the trust and forget that there's some things that they need to do administratively, and now since they revoked the trust itself, it's hard to update the title. But if the trust is in effect, and say you had an LLC that was deeded to it, and then someone gets rid of the LLC, whatever, since the trust is the owner, they'll just get the cash from whatever no longer exists. Or if they own a building and the building burned down and there was some insurance proceeds, they would get the insurance proceeds. So usually, as long as the trust is in existence, if something that it owns goes away, it's going to get the funds from that.
Okay. That was the last question in the chat.
Okay, thank you. Okay. I specifically wanted to mention this is called heirs property, and I wanted to build on our discussion of having intestate situation where most people have not had a will. If they pass away, the property doesn't have a formal owner until probate happens. Or, and we'll read here, so what is heirs property? Home or land that has been passed from generation to generation without legally documented a designated owner. Okay, so basically this is a situation that's happened, especially in the South. A lot of times, say, grandparent has the property, grandparents have the property, they pass away, the other family members take over the property physically. They pay the taxes, right? The taxes come in the mail or some other format where they know that they have to pay the property taxes to keep the property. Someone cuts a check. So for years, people are cutting checks. People are still living in the property as if it is theirs, but they don't have formal title to it. So what happens is eventually, as each generation keeps passing away, there become technically more and more owners, right? So originally that first couple may have had 3 kids. Well, if each of those 3 kids had 3 kids, now it's starting to balloon where you have multiple owners. Then the next generation has 3 kids each, and then it's ballooning. So now you could have a property with 30, 40, 50 owners on it. Okay? So that's the second part. The owner dies without a will, so the property passes to heirs at law. Who knows who those heirs are, because no one's really been identified. No one goes to court. And then eventually someone wants to do something with the property. Oh, this property is now valuable. I want to sell it. And then you realize you have umpteen owners. The other time is created is when we have to be careful, is when someone dies with a will, but we still leave property to multiple relatives. So what happens by default? A lot of times parents say, okay, I have 4 kids. I want to leave each of my children a piece of this property. You are creating heir property. You have 4 people that have probably most likely a quarter interest in this property. They're called tenants in common interest usually, so that if each one of them passes, the other 3 don't inherit their share. It passes down through their will, or if they're intestate, through the intestate process. So you wind up having the same effect with multiple owners. Why is this a problem?
Got about 3 more minutes, Keith.
Okay.
We've got about 3 more minutes.
Okay, trying to move my slide is not. All right. So this is what I mentioned, cloudy title. Grandfather had it, remains in grandfather's name. Heirs who inherit the property do not have clear title to the land. Land eventually passes to many heirs. Why is this a problem? There's something in the law when you have tenants in common, where you have all these different owners. All it takes is one single owner to say they don't want to stay in that situation and ask for a partition by sale. If they do that, they will then have, the court will say, okay, we're going to auction off the property. Now, if you're familiar with auctions, especially auctions under duress in estate situations, that means you're probably not going to get offers that reflect full fair market value. Then what happens, the property is sold, and then everyone gets their piece, right? So in this situation, everyone would get their 1/4 presumably, but maybe those other 3 number one, didn't want to sell. They may have wanted to keep that property in the family. And 2, the proceeds that they received may be well short of what they would have received if they had gone through a formal sale process, trying to get an agent and going through that process. So this has resulted in African American land loss. Okay, so from 1910, there was 16 million acres operated by American farmers, 14% of farms. Now today it's under 3 million acres, only 1.5%. We've lost 80% of land from 1910 to 2007, and we're still doing this because this requires us to think about different ways of leaving property. Maybe we leave property into entities, LLCs, S corps, and then have them with operating agreements that say, the other owners have right of first refusal to buy, or don't allow certain people to come in. That's not family, keep it as a family kind of LLC. So this is something to think about, especially when we're talking about wealth, is to understand it's not just having a will or having a trust. You have to think about the logistics of how things are going to pass and the effect of how things are going to pass. I mentioned beneficiary designations. Of course, that's going to be a large issue, as we have most of those tax deferred. So they're going to grow. Someone might be 40 now with $1 million. And by the time you get to required minimum distributions 30 years from now, it could be far larger. Not going to get a chance to talk about it fully, but if you're paying attention, Biden has some tax changes that are proposed. There's something called a step up in basis. So usually if you had a piece of property, you've heard probably the saying, you know, grandma and grandpa bought that house for $30,000 and now it's worth $500,000. Under step up in basis, if they kept that till they passed away, they would hold that property in their state. It would get a step up to whatever the fair market value was at date of death, say $500,000. So if they pass it on to their children and the children sold it for $500,000, there'd be no capital gain. They're trying to change that and eliminate the step up. So that would raise a lot of taxes on people at death, because now the heirs would not be able to get that kind of step up. So we have to pay attention to a lot of things that are happening on the tax front. I know a lot of people hear taxes and they kind of cringe and back up, but there's some estate tax things now. There's a current exemption of 11.7 million. That's supposed to end in 2026 and go back down to about 6 million. They're proposing to move it forward to the end of this year. So at the end of this year, you could potentially have a $6 million exemption. Why does that matter? Most people say, I don't have that. Well, you have to know how a gross estate is formulated, and you might be a little more concerned. It's not only what you see, it's not only the house, the car, it includes your stocks, it includes your IRA, 401k, it includes your life insurance. So you say, well, how can I include my life insurance? I'm still alive. The fact that you have control over that policy, the face value of that is calculated by the IRS in your taxable estate. So many people, especially if they have life insurance, expensive houses, IRAs, they can get to the $5, $6, $7 million mark fairly easily, especially if they live in states with expensive, homes, California, New York, Illinois. So just want to make sure we're aware of these kind of changes that could happen. Like I said, and some of these changes might be retroactive if they pass them for 2021. So just keep an eye out for these tax bills, because we know they're talking about right now, is it a $3 trillion bill or is it a $1 trillion bill or a $2 trillion bill? They're going to have to pay for those things, and they're going to pay for them by trying to tax us more. So we have to be diligent. That's pretty much what I have right now.
All right. Well, thank you, Keith. And it has been very enlightening. I think the thing that's so important is that, we don't plan to fail, we fail to plan. And I want to share just a really quick note. So about this time, it was in November of last year, so it's almost a full year. And I had called a buddy man. Well, buddy man had actually called me, and I was returning his call. And when I returned the call, his wife picked up the phone, picked up his mobile phone. And so that was my first clue that something was wrong. And when I heard her voice, that was the second clue. And she told me that he had just died. I was just floored. And later on, I found out that he died without a will and no insurance. Now, this was a very successful businessman, had just landed a $5 million contract through the county in Broward County, and his business was definitely on the uptick in terms of a trend. Had 2 boys, one still in college, and had been saying he's going to get around to it, he's going to get around to it, he's going to get around to it, and never did. Ladies and gentlemen, I can't tell you all of the wealth managers and financial planners that I know who tell me just story after story, not only of people who fail to plan and they don't do it intentionally, it's like an accident, you didn't plan for it, but it still happened. And but also the folks who sometimes are just somewhat, how should I say, basically don't necessarily care, I guess is a simple way I can put it, because they feel like they've worked hard and they left, whatever they've accomplished and what they've achieved and acquired, And if the taxes is going to eat it all up, well, that's okay. I don't need to take out an insurance policy to cover the taxes in order to make sure that it passes on to my heirs and to my heirs' heirs. Guys, please, 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 just don't fail to plan, okay? If you take a moment and listen and take advantage of people like Keith Miles to help you to put your affairs in order, the simple truth is that we will never pass on generational wealth if we don't plan for it to happen. So Keith, thank you so much for taking time to be with us today. And Keith is in Atlanta. He's a member of the ICABA World Community, so you can always reach him there. He maintains a estate planning mastermind group in the community. So he's very active there. And we are just thankful that you were here. We hope that you have a wonderful night. And we look forward to seeing you tomorrow for another Black Professionals Month Day. And Denise, if you're there, if you want to say something before we check out, please do.
I am here. Thank you, Keith. That was fabulous. I took some notes and I thought I was up on top of all of that. I realized, oh, wait, I should be doing some of this. So I know that your words of wisdom, at least some of them, are going to strike a chord with some of us. So I thank you for sharing all of that information, that wonderful advice, making us think, which is what Black Professionals Month is all about. So yes, great session for sure. So thank you. And thank you everyone for being here. It's getting a little late in the evening. So the fact that you are still here with Black Professionals Month, I appreciate that for sure. So thank you. And we'll see you guys tomorrow.
Thank you, guys. Appreciate the opportunity.
All right.
Absolutely. All right. Good night, guys.
All right. Be blessed.
Bye-bye.